Hi everyone, so with this video we are entering into part 8 of Indian Constitution that deals with union territories. As part of our discussion on Indian polity, prior to this we already have discussed part 1 of Indian Constitution that deals with union and its territories. So part 1 deals with union and its territories, while part 8 deals with union territories. Just one part of part 1 is being discussed in part 8 of Indian Constitution. So part 1 deals with union territories, states and states that can be, or entities that can be acquired by India in times to come, right? So I hope you will have clarity on difference between part 1 or coverage of part 1 and part 8. So part 1 we already have covered. Part 2 was dealing with citizenship. That portion as well we have covered as part of our discussion on Indian polity. Part 3 deals with fundamental right. We already have covered there. We had spent more than 7 or 8 hours. Then part 4 of Indian Constitution, DPSP, has been covered. Part 4A, fundamental duties, in 1 hour lecture we had spent around on fundamental duties as well. Then part 5 was dealing with the union. So that chapter or that part of Indian Constitution we had spent around 12 hours, if I could remember correct, right? So there are 7 or 8 videos on the union section alone, right? So there we discuss this prime minister, cabinet minister, Supreme Court, parliament, right? So all those things we have discussed as part of our discussion on part 5 of Indian Constitution. Then we discussed part 6 of Indian Constitution that deals with state. Part 7 has been repealed. Now we are into part 8 of Indian Constitution, and prior to this part 8 of Indian Constitution we already have covered part 9 and 9A as well. What was this part 9 and part 9A deals with? If you remember, that was the previous videos, right? So part 9 deals with the Panchayati Raj institution and part 9A deals with municipalities. There is part 9B as well, right? What it deals with? So that is a question for you. But let me tell you, this part 9B deals with the cooperative. So cooperative we'll discuss at a later stage, right? So with this video we'll be able to cover until part 9 of Indian Constitution. As I already told you that prior to part 8 we already have covered part 9 of the Indian Constitution. Now without wasting time, let us move to the next slide and let us start discussing what is going to be the scope of this video. So even before discussing the scope of this particular video, let us discuss that there are certain prerequisites, there are certain things that you need to know before coming to this chapter. So what are those things? So I'll expect that you will already have an understanding of part 1 of Indian Constitution that spans from article 1 to 4, that is a chapter dealing with union and its territories. So if you remember, we already have delivered a video lecture on this union and territories as well. So I'll expect you that you will have an idea on that part 1 of Indian Constitution, because we will be taking reference of evolution of state, how states in India has been added into the state list, how union territories were there and those union territories were transformed to the state. So those kind of information that we had, right, in the union, the discussion that we had in that chapter, right? So that is going to be the basis, that is going to be the premise of this particular video. So I'll give you a beforehand information that if you do not have understanding of that chapter, I'll urge you to leave this video right now and watch that lecture before coming to this video. So having declared the prerequisite for this particular video, we'll delve into the core of this video and we'll respond that what is this union territories and why union territories has been created. When we boast ourselves to be a federal nation, we aspire to be a federal country like America, right? So what is this union? What is the point? We'll discuss that union territory is nothing but a unitary character or tilts the balance when we were discussing again this federal chapter. So that is the second prerequisite for this, that you need to have understanding of what is this federalism, what is this unitary features of the India. So when we were discussing again the salient, the chapter 3 of the Lakshmikant that deals with the salient features of Indian Constitution. So there we had discussed that this feature of union territory is nothing but a unitary feature of the Indian Constitution, and that tries to tilt the balance of Indian federalism in the favor of unitary feature. What are the other unitary features and what are the federal feature? We had differentiated there. So I'll expect again that you will have an idea or conceptual clarity on that what is this federalism, how India is federal despite having so many unitary features present into, so what are those unitary, so presence of governor, these IAS officer, right? So these features that we were discussing into the salient features of the Indian Constitution. So there we had discussed that besides those features, right, this union territory is presence of union territory, or this political entity called union territory is a unitary feature. So what is this necessity when we are boasting, or when we are aspiring to be a federal nation? What is the point of having this union territory? Why we do not translate these union territories into, or why we have not given the statehood status as Delhi has been demanding, right? What is this problem in giving the statehood status to whatever union? Rather, we had done the contrary thing. We had a full state, Jammu and Kashmir, in 2019 August. We transformed that full state, and this has happened perhaps for the first time. Again, I'll give a reference to the chapter 5 of Indian Constitution. If you remember, with the evolution after 1956, you had many. We started with 6 union territories, and at later stages in 1960 and 1965 and 90, we had many union territories that kept coming on. But with time, with passage of time, what we did is that to the whatever union territories, at one extent, right, we had more than 10 union territories. But gradually, as soon these union territories, right, gained some kind of confidence, right, we transferred, or we changed these union territories, or we gave them status of the full state. So what necessitated means, this time the Jammu and Kashmir has been, this is the first time that a state has been demoted to the status of this union territory. So what was this necessity? Why do we create these union territories? Why do we do not? Delhi has been, as I already said that Delhi has been demanding this statehood, especially after arrival of this AAP government. So what is this problem problem in giving full or granting full statehood to Delhi, right? So that aspect we'll see, that why these union territories, what are the historical reason, what are the cultural reason, what is this cultural distinctiveness, what is this cultural uniqueness, what is the security angle, what is the strategic angle behind creating or behind having these union territories. Then we'll discuss the historical genesis of union territories, like how many union territories we had after the independence. Did we really have something called union territories after the independence when constitution was operationalized, or this union territory terminology has a post independent genesis? So that we'll discuss in this vertical when we'll discuss the historical genesis of what you call this union territories. And then we'll discuss that how the union territories like Dadra, Nagar Haveli, Daman, Div, these Lakshadweep, Andaman, Nicobar, Puducherry, J&K, so how the administration would run in these kind of union territories. We'll see the classification of union territories as well. So you have these 2 level of classification among these union territories as well. You have some union territories without legislature, and you do have 3 union territories like J&K, then you do have this Puducherry and NCT of Delhi. So these 3 union territories are with the legislature. So we'll see that how do administration, who is responsible, who is going to be the nodal agency as far as administration and legislation of these union territories is concerned. Thereafter you do have 4 MCQ at the end of this video that has been appended for you to attempt, that I expect you to answer us in the comment section. So with this introduction, let us enter into the next slide and let us start discussing the core of this video. So these are nothing but 22 parts of Indian Constitution that we do have with the article and with the subject matter. So that point we already have described. So right now we are going to discuss this part 8 of Indian Constitution. From part 1 to part 6 we already have covered, and part 9 as well, and 9A as well. So until this point, with this video we would be able to finish until this point, right? Cooperative will be done at a later stage. After this video we'll be delving directly into part 10 of Indian Constitution. So as I already told you that when we'll be dealing with these constitutional bodies, there we'll discuss these cooperatives, the cooperatives that were inserted into Indian Constitution by 97th Constitutional Amendment. So after this video, as I already told you, that we'll be delving into part 10 of Indian Constitution. that deals with the scheduled and tribal area. There we'll discuss 5th and 6th schedule of Indian Constitution, right? So these are nothing, these two slides deal with the parts, various parts, 22 parts of Indian Constitution, the subject matter and various articles, right? So I hope you will have clarity on that, how we are moving from one article to another, from one part to another, and we are completing those parts one by one. Now let us try to understand that what is this union territory. So first we'll address this what part, that what is the union territory, and next, on the next slide, we'll try to respond that why union territories has been created and why they are sustaining until today, until 2020, right? What is this necessity? So now let us first respond to the first question, that what are the union territories, right? So again, I'll have to go to the federal system lecture, where we had described that we do have two kind of political units, and when I am talking about these political units, I am by no means that BJP or Congress. The political units that I am talking about, I'm talking about union and the states, right? We do have this third political unit as well, that we discussed in the part 9 and 9A of Indian Constitution. But right now, when we were discussing federalism, right, we are not concerned about this third tier of governance or third political entity. Otherwise, you can describe this third political entity as panchayat and municipalities. Coming to this lecture, so when we were discussing this federalism, right, or federal system, we had described that we do have two political units, and with the states, right, the entities which has been described states. So here I am meaning these Madhya Pradesh or Maharashtra or the 28 states that we do have. So with these states, you do have something called Schedule 7, and in Schedule 7 you have list 1, list 2, list 3. So there are different matters into this list 1, list 2 and list 3. What are the matters? So the matters that is mentioned into the list 1, on those matters legislation can be made or enacted by the union. The matters that is mentioned into the list 2, on those matters legislation can be made by or enacted by the states, and the list 3 that deals with concurrent list, on those both union and state can legislate. So there we had discussed that as far as state is concerned, with the state this union shares this federal relation, right? There is distribution of power, and the distribution of power is by the constitution itself, right? Many a times we discuss the union, the position of union or the state, right? We do make mistake that state's position is at the bottom or state position is at the inferior to the union. No, that is not the case. We do have, means constitution has equally recognized these union and state, and these two entities, union and state, they derive their powers from the constitution, right? The powers that state does have in no mean has been extended by the parliament, right? Both these entities, union and states, does derive their power from the constitution itself, right? So those are equal entities. It's just that for the matters of uniformity, wherever those uniformity in the legislation is required, those matters has been given to the union, and matters that are close to the people, development function, these law and order, so those kind of thing has been put up into the state list. So that clarity we do have. Now what about this union territories? So with this union, so if you see union territories means these are the territories or the entity that has been described as union territories, those will be directly ruled by the union. That was not the case with the state. At the union level you do have this government, separate government election, and at the state level you do have separate government, separate legislature. That is not the case with the union territories. With the union territories, unions share a unitary kind of relation. What is the difference between federal relation and what is the difference between unitary relation, right? So here union is going to direct or union is going to legislate on the matter. So you do have in the relation of union territories, so you do have like NCT of Delhi, Jammu and Kashmir, Dadra, Nagar Haveli, Daman and Diu. Mind you, this Dadra and Nagar Haveli and Daman and Diu, right, their merger has been affected in January 2020, right? Bill had been presented in November itself into the parliament. So these two entities that were separate earlier, Dadra and Nagar Haveli and Daman and Diu, has now been merged. So that is one information. So as far as union territories are concerned, I was talking about this union shares a unitary unitary kind of relationship, and the meaning of unitary kind of relationship is that these territories or these entities that I was referring to right now, Dadra and Nagar Haveli, Daman Deep, Puducherry, Andaman Nicobar, Lakshadweep, so these territories will be, administration and legislation of these territories will be done directly under the administration or under the supervision of Union itself, whereby Ministry of Home Affairs is going to be nodal agency that will be dealing with all the legislative, executive. However, there are nuances. You can talk about the status of New Delhi, you can talk about the status of this Jammu and Kashmir, that they do have their assembly, but that is a nuanced part that we'll have a discussion later into this video. When we'll delve deeper, we'll discuss the classification, that you do have these two kind of classification where there are 3 union territories which has been given this special position whereby they do have their own state legislative. However, as far as legislative power is concerned, they do have constraint legislative power. Just by having assembly does not mean that parliament or the union will not have any amount of control over those. So the plain and simple definition of this union territories would be the territories or the entities or the political units that will be directly administered by the union. Again, I am giving you a rider that you might argue that there are these union territories like New Delhi and Jammu and Kashmir and Puducherry, which does, so that we'll discuss and we'll have later. So I hope you will have clarity on that, what is this union territories. Now we are entering into the next aspect or next leg of this video to respond that why this union territories has been created. This question I had raised into the introductory section of this video itself, that union territories as a political entity is promoting these unitary characteristic into the Indian constitution, and when we boast about the federal characteristic of the Indian constitution, and when we were attempting ourselves to be called as federal nation, we can abolish these union territories and we'll have another reason to boast ourselves as a federal nation, right? So what is the reason behind having these union territory? Rather, we have done a contrary thing. Instead of having whatever union territory that we had until now, right, we had a demoted status of one state, that is Jammu Kashmir, from full state to these union territory, right? We are doing a contrary thing. There is demand from union territories like New Delhi to convert union territory status into the full state, and we are doing completely contrary thing. So let us try to understand that what is the justification that we do have behind having whatever union territories that we do have, right? And what is the justification behind demotion of Jammu and Kashmir as a union territory. So the reason behind having union territories into the Indian constitution or India can vary from cultural uniqueness to the other special consideration. You can have security reason, you can have strategic reason, you can have political reason. So let us try to understand that what are the reasons or what are the justification that we do have behind these Jammu and Kashmir's demotion, behind mergers of Daman and Diu and Dadra and Nagar Haveli. So let us pick the most recent case. The most recent case is of merger of Dadra and Nagar Haveli and Daman and Diu. That was, the merger was affected in January of this year itself, that is 2020 itself, right? So let us try to understand that what is the justification. So the justification behind merger is administrative convenience. So the culturally, as far as these two union territories, right now they are one, right? So these two union territories, which was until January 2020 as two individual union territories, culturally they share similar relationship. Both these entities has been ruled by Purgatis. So they do have cultural that is similar to each other. As far as cadre and the service management, as far as implementation of various centrally sponsored scheme or centrally sector scheme was concerned, right, the implementation and the cadre and the service management, right, it all, in all these aspects, it was leading to the duplication of effort, it was leading to the duplication of paperwork, and that's why center decided to merge these two politically connected entities because of their cultural similarity. So there the justification was administrative convenience and cultural similarity behind merger of these Dadra and Nagar Haveli and Daman and Diu. The other state, that is Jammu and Kashmir, is concerned. So for Jammu and Kashmir, the reason can be security angle and strategic importance. It does share boundary with China, it does share boundary with the Pakistan, and you already know, as far as Jammu and Kashmir as a state was concerned, you had foreign intervention. Earlier it was Pakistani hand only, right now you do have the Chinese intervention as well. So it was necessary that for the strategic reason, because we have not been able to solve the security situation, we have deployed army since 90s and we have not been able to solve the security problem there. So it was necessary that the state, full state, is demoted to the status of union territories, right, so that union or the parliament can intervene whenever the security situation. Earlier, because of this article 370, right, this 370 was constraining or restraining many of the options that could have been used by the parliament or union, and that's why. So from security and the strategic importance, right, this J&K demotion can be justified. As far as Andaman and Nicobar's continuation as a union territory is concerned, the Andaman Nicobar's status as a union territory can be justified from strategic angle. So if you have been keeping yourself update with the international affairs, so you would know that there is something called Malacca Strait, right? So various kind of strait you do have. So Malacca Strait, and again there is one terminology that is used into the international relation, and that is Malacca dilemma, right? You do have these Chinese incursion or Chinese ships ongoing from this Malacca portion, and then American ships that is coming from Pacific Ocean into the Indian Ocean. So here, just below this Andaman Nicobar, right, you do have this Malacca Strait, and here because of various kind of foreign nations, their submarines do remain present. So from the strategic angle, you can have, means you cannot grant the full statehood status to the Andaman Nicobar. As far as Chandigarh and Delhi's region as a union territory is concerned, their continuation as a union territory can be justified from the political reasons. For the political reasons, you cannot grant Delhi a full state. You cannot make Delhi as a full state. If you have an idea on the Balakrishnan report that was submitted to the Indian government in 1988, regarding not transferring, why Delhi cannot be granted full statushood. So there we had, there the Balakrishnan report had pointed out that you do have foreign embassies, and if you do have this Delhi region does not happen to be just any kind of state like Uttar Pradesh or Haryana, it does happen to be capital of the nation. And if at any occasion if there is opposing party that is ruling center and Delhi as a state, then in that case there will be friction between, and that is not something good for any particular city that happens to be capital or where foreign embassies are stationed, right? So political reasons for Jammu and Chandigarh and Delhi. As far as Puducherry is concerned, so Puducherry continuance as a union territory can be justified for the cultural uniqueness that it has. If you know the population composition, still this Puducherry is or have traces of the French. If you know, this Puducherry was not part of India until 1954, although we got independence in 1947. But we got only these British portions from the Britain in 1947. This Puducherry region was part of France until 1954, and it was only in 1954 that we acquired this Puducherry. So Puducherry does have huge amount of traces for the France population. Rather 10,000 people or 12,000 people still they reside into the Puducherry, but still they do hold this French passport, means basically they are French nationals. As far as the election for the president or any other election is concerned that is conducted into the France, these people, 10 or 12,000 people that do reside in separate colonies, right, they do vote for or they do participate into the voting while being in India. So that is a unique information. French embassy into the India, they do make voting arrangement into the Puducherry when this election into the France happens, right? They do celebrate all the New Years or all the events of the France, right? So that was, so you will find, as far as cultural uniqueness that I was talking about, although there are only 10 to 12,000 that do hold French citizenship, but more than 60% of the people, right, they do have acquired the Indian citizenship, but more than 60 or 65% of the people you will find will have any kind of links at least with the France. So it is because of the cultural, and moreover the sizes of these Andaman Nicobar or the size of this Puducherry, if you leave alone this Andaman Nicobar geographically happens to be very big, but as far as size of Puducherry or Daman and Diu, Dadra, Nagar Haveli, or Delhi or Chandigarh, if you see, right, it geographically it is not very large to be granted status of a state, right? So that can also be, the size can also be factored. So I hope the why aspect, that why union territories, would have been answered to you. Let us move to the next slide and let us start discussing the historical, let us start tracing the historical genesis of union territories. So again I'll have to go to that chapter union and territories, where we had described that into the Indian Constitution at the time of operationalization in 1950, we did not have something called union territories. What we had in 1950 is the fourfold classification of the state. We had 29 states at the time of independence, but those 29 states had been broken or had been put into these Part A, Part B, Part C and Part D. In Part A and B you had these 9 states, in Part C we had these 10 states, and in Part D we had this lone Andaman Nicobar. So as far as Part A or 9 states, that is into the Part A is concerned, those 9 states were those states that were part of governors' provinces before 1947. As far as 9 states that were put under this Part B of the classification, so you had various princely states that formed part of Part B. Now for this chapter it is going to be this Part C is going to be the importance. Let us see that how this Part C of 10 states into the Part C, right? I am not feeling quite well today, perhaps I'll have to take break, and this video means I am stopping this recording right now. Perhaps this video will be clubbed with another day recording, and then I don't know, means I had this fever and I'll have to take break. Hi everyone. So yesterday we were discussing this historical genesis of union territory. So let us start our discussion from there itself. So yesterday I had clearly pointed out that at the time of operationalization of Indian Constitution in 1950, we did not have anything called union territory. Rather, what we had is, we had 29 states, and those 29 states had been divided into these 4 parts: Part A, Part B, Part C and Part D. Why this classification had been created, what is the importance of this Part A, Part B, Part C and Part D, that is not the scope of this video. All these points already had been discussed into the union territories lecture. Rather, the slides that is being used in this lecture is direct copy paste from that lecture itself that you can see on the screen, right? So because of the paucity of time, in this video I will not describe that what is this Part A, Part B, Part C, but there is a purpose, that's why I have put up this slide here. So the concern that we do have means, at the time of independence, I clearly told you that at the time of independence we did not have this union territory. Rather, what we had is that this Part C, that is commissioners' provinces, and this commissioner provinces can be indirectly called as union territory. So let us try to understand that how these 10 political entities or 10 states lying into the Part C of Indian Constitution were being ruled. Let us first try to understand that what were those 10 commissioners' provinces, and thereafter we will discuss that point, that how these 10 political entities were being ruled. So you had these entities like Bilaspur, you had these entities like Himachal Pradesh, Delhi, then Bhopal. So these kind of 10 entities that you can see on the screen, Kuch Bihar, Kurg, right? So these kind of 10 entities that we had. Now let us try to understand that how government would run, right? In the regular states like these Odisha, Uttar Pradesh or Madras, right? So in those states you had these elected government like we do have at the central level. In those kind of states that were lying into Part A, Madras, Bombay, Odisha, Bihar, Madhya Pradesh. So these states, these numbered in 9. So here you had this regular election that we do have today at the assembly level, and thereafter there would be appointment of council or minister. But as far as these Part C states were concerned, here center would appoint commissioners. The name of the post was commissioner. So center would appoint the commissioner, and center will rule on these areas, these territories, through those appointed commissioners. So much like today, the kind of arrangement that we do have today for the union territories, right? That kind of arrangement you can see into these Part C entities. So these entities can be very much described as a union territories, at the time of these entities or these system of governance did exist at the time of independence or at the time of operationalization of Indian Constitution. But again I am pointing out that in relation to these entities, in relation to these states, word union territory had not been used. Now when this word union territory would be introduced into the Indian Constitution, so you will notice that from 1952 itself there started demand of various state on the linguistic basis, and when this demand started, you had this establishment of various committees and commission. You had this Dhar commission, you had this JVP committee, and then finally you had this Fazl Ali commission. Finally this Fazl Ali commission in principle accepted that yes, states can be reorganized, but language cannot be the lone basis. At the time of giving its recommendation, this Fazl Ali Commission, right, in 1956, it suggested union to create these 3 UTs. No, UT had not been recommended. The word that was used into this Fazl Ali Commission was centrally administered area, centrally administered area, CAT. But you will notice that this centrally administered area, centrally administered area, CAA it can be called, right, centrally administered area, right, that was changed, this word was changed by the union, and in relation to the recommendation, this word union territory was introduced by the center or by the union in 1956. So if a question is asked that when this word union territory was introduced into the Indian Constitution, or when this setup actually in this union territory format came into the Indian Constitution, you will say in 1956. But this Fazl Ali Commission, recommended for the establishment of union territory? No, Fazl Ali Commission had recommended for the this establishment of, means structure was going to be same, the ruling was going to be same, how those areas will be ruled, that will be ruled. So those arrangements, those provisions were same, but the word that had been used by this Fazl Ali Commission was not union territory, that was centrally administered area. One more thing, that Fazl Ali Commission had recommended for the establishment of only 3 centrally administered area, while union, you will notice that in 1956 union will create 6 union territories, including Delhi itself, right. So you have this list of 6 union territory that you can see on the screen. You have this Andaman Nicobar, you have this Delhi, you have Tripura, Manipur, right. So these kind of Himachal Pradesh, and this Lakshadweep. Lakshadweep at that time was not described as Lakshadweep, right. It was being described by these many names that you can see on the screen: Lakadweep, Lakadive, Manikoy, and Amendevi Island. So these were 6 entities, or these were 6 union territories that came into Indian Constitution or in actual existence in 1956, and thereafter, means again you will have to go back to your understanding of chapter union and its territory. There were mergers, or there this list kept expanding on, kept decreasing from 1950, 1960, 1970, 1988. By 1970, you will notice that most of the northeastern state will come into this list. So this list of union territory will keep increasing and decreasing. First, most of the state that will be broken in the northeastern part I am talking about. So Assam will be broken into many parts. You will have Nagaland, you will have Manipur, you will have this Meghalaya. First they will be made union territories, and thereafter when they will attain some kind of confidence in the governance, you will see, or when there will be demands, right. So center will transform, or center will change their status from union territory to the state. So that kind of provision you will notice. So we started with 6 union territories. At a time we went on to have these 10 union territories. At right now in 2020, if I talk about, we do have these 8 union territories. When I am saying 8 union territories, I am considering the merger of Dadra and Nagar Haveli, Daman and Diu, and I am also considering the demotion of J&K, or the split of Jammu and Kashmir as a state into 2 union territories. So right now in 2020, when this video is being recorded, you do have 8 union territories. So that you can see on the screen, there are 8 union territories. So this should have been divided rather the editable map that we had to be used on the slide, right? So in that map this has not been divided. So here you can consider this Jammu and Kashmir to be divided into two union territories. In the western part, or the part that is touching with the Pakistan, that area will be called Jammu and Kashmir Union Territory, and it will have an assembly. The portion on the eastern side sorry, the portion on the eastern side will be described as Ladakh, right? So that is the two union. If we start from what you call this northern side, so here you do have two union territories, then you will have this Chandigarh here touching with this Punjab and Haryana, right? Then you have this Delhi. Thereafter here you have these two merged union territories right now. So this will be considered as one union territories, that is Daman and Diu, and Dadra and Nagar Haveli. Then on the western part you have this Lakshadweep. Then you these 4 points rather, right? Mahe, Yanam, Karakal, right? So these four entities collectively, and this Puducherry, this will be called Puducherry, right? So 4 regions that is spread. So this is one special feature of this Puducherry, that it is spread over these 4 geographical regions, and it is spread into these 3 states, that is Andhra Pradesh, Tamil Nadu and Kerala, right? Thereafter you have this Andaman Nicobar. So these are the 8 union territories that you can see on this screen. So right now the most recent union territory is this after merger, it is called the Daman and Diu and Dadra and Nagar Haveli, that was being affected in January 2020. The bill had been bill in regards to the merger of these two union territories for the administrative convenience was introduced into the parliament in November 2019, and it was finally, it has been, this merger has been affected in January 2020, and thereafter the second most recent addition is of Jammu and Kashmir, which was split into 2 parts, right? Now this whole of the 8 union territories can be classified into 2 parts, and the 2 divisions will be on the basis of the one which does have assembly, and the another classification can be the list of union territories which does not have their assemblies, right? So you do have these 3 union territories which does have, and that is one basic information, right? So these 3 union territories, earlier you had these 2 union territories, that is NCT of Delhi and Puducherry. Right now after this creation of Jammu and Kashmir, what you had is the Jammu and Kashmir has also been given assembly. So these are 3 what you call union territories that does have their own assembly. Thereafter you will have another classification that does not have their assembly, and in that list you will have these 5 union territories, that is Ladakh, Chandigarh, Dadra and Nagar Haveli, Daman and Diu, Lakshadweep and Andaman Nicobar. So right now we do have these 8 union territories. So I hope by now you will have an understanding on the historical genesis of union territories and how these union territories have evolved after independence. What is the current number? So you do have these 8 union territories. Now without wasting time, let us move to the next slide and let us start discussing the administration and legislations in these union territories. If I talk about the legislation, you do have states, right? So in states it is the assembly which does enact legislation either for the development matter or for any policy matter. It is the state assembly that designs these legislation. But as far as union territories are concerned, which body is going to, either it is president or is there any other body that is going to, so in this slide we'll discuss on that part. As far as administration, so administration as well, we'll discuss that how administrations run in these union territories. So talking about this administration, you have this article 239 that talks about that how these areas, how these union territories will be run or how these union territories will be administered. And this article 239 reads that union territories will be administered by president. So stop here. Let us repeat it again. Union territories will be administered by the president, but the question arises that will the president directly administer these union territories? So the answer is that no, president is not directly going to administer these union territories. What he will do is that he will appoint or he will rule these union territories through this administrator. He'll appoint an administrator. Of course, when I am saying that president is going to appoint an administrator, it is not his discretionary power. He'll do so on the advice or on the recommendation of cabinet, on the recommendation of Union Council of Ministers. So president, although president is not going to directly administer this union territories, these union territories, what he'll do is that he'll appoint these administrators and he'll rule these union territories through these administrators. However, he does have liberty that he can change the designation of these administrators, right? He can have the name, or he can designate him as lieutenant governor, he can designate him as administrator, or he can designate as chief commissioner. And consequently, you will notice that you do have these 3 union territories where you have this administrator. So you have this Dadra and Nagar Haveli, the recently merged union territory, then you have this Lakshadweep, and then you have the Chandigarh, right? So in these 3 union territories, what you have is the designation called administrator, while the other 5 union territories, that is starting from Jammu and Kashmir, then Ladakh, then you have this Andaman Nicobar, Delhi, Puducherry. So in all these 5 union territories that I just counted, there you have this lieutenant governor and not administrator. So you have in 3, let me repeat, in the 3 union territories what you have this administrator, and in other 5 union territories what you have is this lieutenant governor. So that was on part of designation, that how these designations. So it is ultimately means on president that what designation he is going to have to these administrators. Ultimately all these will be called administrator, but just name change has happened, just designation change has happened, right? So that is one thing. However, at any time the situation may occur that center or this council of minister may not find any suitable candidate for a particular union territory. In that case, center does have option, or president does have an option that he can ask the adjoining states governor. So let us try to understand. So you have the Chandigarh. Chandigarh is surrounded by this Punjab and the Haryana. Now at any time if Chandigarh's administrator is to be appointed and center does not, or president does not find any suitable candidate, or if there is a delay of 2 months, right? So in or 4 months, or for a unlimited time there is a delay, in that situation he can ask Haryana governor to take the additional charge of this Chandigarh region. Similar can happen with the Puducherry as well. So you have this governor in Tamil Nadu. Tamil Nadu governor or Andhra Pradesh governor can be asked or can be suggested to take additional charge of Puducherry region as well. So that is one option, that governor of the adjoining state can be appointed as administrator to the union territory. So I hope the adjoining state you will have understood. In this situation, the governor, that particular governor, so let us take example of this Chandigarh. So suppose Haryana governor has been appointed as the administrator of this Chandigarh. In that case, while taking the decisions for the Chandigarh region, this governor will not have to take advice of the council of minister of the Haryana, right? Let us try to understand it again. He was governor of Haryana. He was appointed, he was given this additional charge as administrator of this Chandigarh. Generally, while taking the decision of this Haryana in matters related to the legislations of the Haryana, he will take the advice of council of ministers of the Haryana. But in case when he has to take any decision on the matters of relating to this Chandigarh region, in that case he will not receive, or he is not liable to receive the advices from this council of minister of the Haryana. So that is the point, that in this scenario governor should work independently without the support of council of ministers of the Haryana. While exercising his functions in relation to the Chandigarh, he need not to have the advice, right? So that was on the part of administration. Now let us start talking about legislation, that which body is going to enact the legislation for these union territories. In case of states, it was the assembly which was designing or enacting these legislations. What will happen into the case of union territories? So for the purposes of this legislation, we will divide union territories into 2 categories, category 1, category 2. In category 1, let us put up all those union territories which does have their assembly. So you do have these 3 union territories, Puducherry, NCT of Delhi, and recently created this Jammu and Kashmir, which does have their assemblies, right? So these 3 assembly is going to design the legislations for those union territories. So on the category 1, I hope you will have clarity. As far as category 2, so let us discuss this category 2 on a later stage. Let us first talk about the legislative powers of this union, these 3 union territories that we have put up into the category 1, because there are certain limitations. When I am saying that they can design or they can enact the legislations into the list 2 and the list 3 item. I hope you do remember what this list 2 and list 3 I am talking about. So I am talking about this schedule 7. This schedule 7 does have these 3 lists, list 1, list 2, list 3. When it was states, right, in case of states, L2 deals with the state list and L3 deals with the concurrent list, right? So in cases of state, on the L2 state was enacting the laws, on L3 state and union both was enacting the laws. But when it comes to union territories, and especially the union territories which does have assembly, right? So those union territories which does have assembly, they will legislate on the matters that has been mentioned into the list 2, and they will also legislate on the matters that has been mentioned into the list 3. Now the question, the legitimate question that you should be raising is that if union territory as well, see, state was legislating on the matters mentioned into the list 2 and state was also legislating concurrently on the matters mentioned into the list 3. But if union territory has also, union territories with the assembly has also been empowered to legislate on the matters mentioned into the state list, then what is the difference between the legislative powers given to the state and what is the difference between the legislative power given to the union territories? So the difference here is that yes, these assemblies, these 3 assembly has been given a degree of autonomy, but this does not diminish, this does not reduces the control of parliament. Even if these assembly, that is Puducherry, Jammu and Kashmir and NCT of Delhi, does design, or they have been given, or they have been empowered to design the laws, to enact and pass the laws, parliament will have ultimate control. If parliament decides, parliament can even after on any matters, suppose on matters related to land or on matters related to anything that has been mentioned into the state list L2, if these assemblies, these 3 assembly have created or have passed any act, if parliament decides to pass an act onto the state list, then the law or then the act that has been passed by these assembly, that will stand inferior to the law or act that has been passed by the parliament on the same subject, right? So that is nothing. Parliament does have supreme power. Parliament at any time in relation to these 3 UTs that does have assembly, parliament can any time choose to legislate even on the matters that has been mentioned into the list 2 that was dealing with the state list, but that is only in relation to the union territories. You will notice when we will talk about these union territories that does not have these assemblies, in relation to those 5 union territories, you will notice that even on the state list, right, parliament is going to legislate for those 5 union territories. So that point we will have discussion on. Right now I just wanted to have a clarity on this point, that parliament does, despite giving assembly some amount of power, parliament, because these are union territories, and that's the difference between a regular state and union territories, that despite giving these union territories a degree of autonomy, a degree of assembly, right, that these 3 union territories has been given, parliament have not lost their control. So I hope that point you will have clarity on. So there are certain kind of limitation that has been put up on the legislation that has been passed by these 3 assembly. Let us start discussing that what kind of limitation that has been put up on the legislative powers of these 3 union territories that does have assembly. So there are certain nature of bill that even before introduction into these assemblies, right, that requires president approval. So that is the first limitation. The second limitation is that there are certain nature of bills that after having been passed by the assembly will be presented to the president, and only when president has given approval, then only that legislation or that bill will become act. So that is second limitation that has been put up on the legislative powers of these union territories which does have assembly. If you see the third limitation on the powers of union territories with the assembly, the third limitation is that in case of Delhi, and this is a popular case, right, you might have, if you are interested into the political subjects, right, you will have an idea that this Delhi keeps fighting, this AAP government keeps fighting with the center and for the full statehood. Rather, they are not completely, means their powers in the legislative sphere not is even on par with this Puducherry and the Jammu and Kashmir, because on the matters related to these three matters, that is police, public order and land, it is not the Assembly of Delhi that is empowered to legislate on any of these three matters. They have been given the powers to legislate into the list, this list 2 that deals with the state list, but even out of those state list, the limited power that they have been given, right, those this Delhi Assembly cannot have any control or any legislation on these matters dealing with these three matters, that is police, public order on and land. So that is one area where the NCT of Delhi Assembly legislative power is inferior to the powers that has been granted to the Puducherry Assembly and Jammu Kashmir Assembly. So that is the third limitation. If I talk about this fourth limitation, so the fourth limitation is that we already have talked about, that Parliament will always have overriding power over any law that has been passed by the Assembly of these three UTs, these three union territories, and should be used. However, the Supreme Court in various cases, various judgment has said that this kind of law, this kind of overriding power or this kind of overriding legislation passes, means if Assembly of Puducherry or Jammu and Kashmir or NCT of Delhi has chosen to pass act mentioned, chosen to legislate on a matter that has been mentioned into the list 2, in that case Parliament should attempt to the possible extent that it should not pass any legislation on that matter. So that power of overriding should be used only sparingly. So these were the four limitations that has been imposed on the legislative parts of the union territories with the Assembly. Now let us move to the next slide and let us start discussing the legislative, who is going to design the legislation for those union territories which does not have assembly. So those union territories which does not have assembly, those union territories does number 5, right? So you have, if you start from top, you do have this Ladakh, then you have this Chandigarh, then you have this Dadra Nagar Haveli and Daman and Diu, then you have this Lakshadweep, and then you have this Andaman and Nicobar. So who is going to design, which body is going to design legislation for these 5 union territories? Because these union territories, for the other 3 union territories that we just talked about, they did have these assemblies. However, they had limitation, but they did have this assembly, and assembly was largely responsible for legislating on the matters that has been mentioned into the list 2 of the schedule 7. But what about these 5 union territories? So in relation to these 5 union territories, right, it is the MHA, Ministry of Home Affairs, that is going to be originating body. So if any legislation has to be created or designed for these 5 union territories, for the governance of these 5 union territories, so Parliament, in the Parliament, the legislations will be introduced, and when Parliament has passed, then that legislation will be effective on these 5 union territories. Now the drafting body, who is going to be the drafting body, or who is going to be the nodal agency for the initiation of these legislations? So the drafting body or nodal body for every kind of thing that is related with these union territories, these 5 union territories, so that is going to be Ministry of Home Affairs. So Ministry of Home Affairs will initiate the drafting of any legislation in relation to these 5 union territories, and thereafter it will be introduced into the Parliament, and this is not regarding only legislations. As far as budget passes, if these union territories need any kind of finances, right, so whatever budget outlays that is introduced, so budget outlays for these 5 union territories will be introduced into the Parliament, and that will form part of the demand of grant for Ministry of Home Affairs. So whatever requirement for whole year that these union territories does have, right, so those requirement will be conveyed to the Ministry of Home Affairs by the administrators and by the local bodies right? And that ministry, whatever budget requirement that these 5 union territories does have, that will be included. So you have, I hope you do have an idea on the demand of grant. You would already have read this budget. So in the budget you have this from various ministry, as part of budget you have this demand of grant. So the budgets of the, so if this union territory called Ladakh, if it demanded 500 crore for a whole year, if it demanded, so figures can be different, right? So whatever amount that these union territories as part of budget will be demanding, that will form part of demand of grant from this Ministry of Home Affairs, that will be introduced into the parliament, and parliament will pass it. So I hope you will have an idea that who is going to design legislation and who is going to be body for passing the legislation as far as these 5 union territories are concerned. Let us read this point. So under Government of India Business Allocation Rule, Ministry of Home Affairs is the nodal ministry for all matters related to the union territories. And what matters? Matters dealing with the legislations, matters dealing with the finance and budget, that we already talk about. One new point that you do have is services. So you do have various kind of services, IAS, IPS, these kind of. So service allocation will also be done by Ministry of Home Affairs in relation to the union territories. Now the point, the bone of contention is that here it has not been clearly mentioned that which union territory this article is talking about, right? Whether it is talking only about these 5 union territories, or whether it is talking about all 8 union territories, which including those 3 union territories which does have assembly as well, right? So who is going to appoint, who is going to do this management of services, which IAS will be appointed, where secretaries to the various ministers, right? And this is going to be the point of contention between most of time when you see the confrontation between Delhi government and Ministry of Home Affairs, or Delhi government and union government, right? This point, this service allocation or the appointment at the higher up levels, you will see because of this in 2015 case had gone, this AAP government had dragged central government Ministry of Home Affairs into the Supreme Court, and LG as well. You had this continuous confrontation from the time since this AAP government assumed the charge, and I am not blaming this AAP government, rather this unclear provision of constitution has enabled, right? The contours has not been clearly defined that up to what point, up to what level of services will be forte of state government which does have assembly. See, as far as those 5 union territories are concerned, they does not have assembly. So on those 5 union territories, center is going to appoint. So there is no point of contention. But as far as these 3 union territories are concerned, which does have their own assembly, which does have been given this degree of autonomy, so there it should have been clearly defined that okay, up to joint secretary level, whatever appointment is being done up to joint secretary level, and rather constitutional functionaries as well. In 2015, when you had this appointment of NCW, National Commission of Women, Swati Maliwal, sorry, State Commission, Delhi Women Commission head Swati Maliwal had been appointed. This LG appointed by center had objected that why I was not sought, my recommendation was not sought. Then you had this appointment of Discom board secretary, right? Then again LG intervened that why my position or why my suggestion was not taken. So in matters of all the appointment, all the major appointment that has happened in last 6 years by the AAP government, somewhere you had this LG lieutenant governor, or rather I should not be pointing out this role of lieutenant governor, rather this unclear provision that says that in matters of union territories related to the legislation, finance, budget and services, right? See, as far as finance and budget is concerned, it is clear that those assembly, whatever resources that they do have, right, they are going to take the decision that according to whatever resources that we do have, we will design the budget. So there is no point on this legislative affair, there is no point on the finance and the budget affair. But as far as the service allocation is concerned, right, you will see continuous confrontation because of this unclear provision. Now there is, let us end this point, let us start discussing about this body. So let us first discuss the composition of this body, and thereafter we will discuss the role and functions of this body as well. So before discussing this function, let us discuss the composition. So Minister of Home Affairs is going to be chairperson of this body, and if Minister of Home Affairs is not present, So if Minister of Home Affairs is not present, in that case Minister of State Home Affairs, he is going to be chairing this body. Thereafter you will have administrators from various union territories. So this body is going to deal with the issues of the union territories, right? So you will have administrator or lieutenant governor, whatever the designation of any union territory will be. So those people, those 7 administrator or lieutenant governor, sorry, 8 administrator or lieutenant governor is going to sit on this body. Thereafter elected parliamentarian. So you have these 3 union territories that does have Rajya Sabha members as well, while all the union territories does have a representation in the Lok Sabha as well. Then members from the local bodies. So you have 73rd and 74th constitutional amendment that is effective in these union territories as well. So member from local bodies also will be, when I am saying local bodies, of course people from Gram Panchayat or the village Panchayat, they are not going to participate into this meeting. Otherwise this is going to be very bulky body and the negotiation and the discussion will become very bulky. So I hope the composition of this body is clear to you. Now let us try to understand कि इसका function क्या है. So function देखो, functions में हम लोग क्या क्या देख सकते हैं. See, these union territories, 3 union territories has been given assembly. So those are representative bodies. These 3 union territories does have a degree of autonomy. They are taking their decision. But what about these 5 union territories? Union territories you have created for security reasons, you have created for strategic reasons, but there should be some amount of democracy that should be given in the decision making of these 5 union territories as well. Although we already have told that Ministry of Home Affairs is going to be nodal ministry in regards to this legislation, in regards to the budget preparation, in regards to any large financial matters, in regards to the service management. So in all these matters, it is the Ministry of Home Affairs that is going, even in relation to decisions that has to be taken into in regards to the local governments, even in that regard you will see the decisions will be taken by the Ministry of Home Affairs, right? So as far as these 3 union territories are concerned, for these 3 union territories to some degree these decisions are being taken by their assembly, and assembly does consist of their elected representative. But here in these 5 union territories that you do have Ladakh, Lakshadweep and all those other 3 union territories, they do not have any representative body, and in absence of this representative body you have this Ministry of Home Affairs single-handedly taking the decision. What is the case means, agar unke paas, if they do have any kind of grievances, right, how there should be any platform where they can take any decision or they can air their opinion. So just to listen to these people, right, if any legislation, so कभी कभी legislation अपनी मर्जी से आप ले आए, आपको feel हुआ कि भाई for the better governance these 2 entities should be merged, and you decided कि भाई दादरा एंड नागर हवेली में डुप्लीकेशन ऑफ एफर्ट हो रहा है, पेपर वर्क बहुत ज़्यादा हो रहा है, तो आपने उन दोनों को मर्ज कर दिया. बट ठीक है, वो डिसीजन आपने ले लिया. बट व्हाट इफ अगर कोई केस ऐसा है जहां ये लोग फील करते हैं, पीपल रिसाइडिंग देयर सिटीजन्स और वोटर्स बिलोंगिंग टू अ पर्टिकुलर यूनियन टेरिटरी इज फील कि दिस पर्टिकुलर मैटर शुड बी लेजिस्लेटेड, राइट? सो देयर शुड बी सम कॉमन प्लेटफॉर्म वेयर they could their representative from the local body, right, they could air their opinion, they can put up their demand. So it is, this body is going to be nothing. This body is just created to be a representative body where the local members from the local body, these administrators, could air their opinion to Minister of Home Affairs, or in his absence to the Minister of State of the Home Affairs, and accordingly they will legislate, accordingly they will put the legislations into the parliament. So that is the purpose of this Home Ministry Advisory Council. So I hope this purpose, this administration and legislation part would be over. Now let us move to the next slide and let us start discussing this Article 239A, right? Again, what is this? I hope you do know the meaning of this A, right? Whenever a suffix or an alphabet is attached to any article, you need to understand that that article is nothing, that sub-article is nothing, that is a later addition into the Indian Constitution. So this sub-article 239A talks about giving legislature to this Puducherry. So Puducherry originally at the time of operationalization, or rather Puducherry was not part of India at the time of operationalization of Indian Constitution. It is an acquired territory that we did acquire from the France in 1954. 1954, right? So through the amendment, through this sub article, right, article 239A, we had given this Puducherry a legislature. So this article 239A talks about giving legislature, right, to this what you call Puducherry. Now, if I talk about Article 239AA sub article again, so this is this has been inserted into the Indian Constitution by 69th constitutional amendment. Now, many a student I have seen confusion. वो सोचते हैं कि भाई this Delhi become union territory by this 69th constitutional amendment. Let me clarify that Delhi was union territory since 1956. It did not. The only thing this 69th because 69th constitutional amendment almost everybody know, right, that through this constitutional amendment जिससे दिल्ली का कुछ हुआ था, right, there were some changes that were made into Delhi composition और दिल्ली के structures में कुछ change. वो change क्या किया था this 69th constitutional amendment. So through this 69th constitutional amendment you had this insertion of sub article 239AA, and the only change or few structural change that this constitutional amendment did was that it gave a legislature to Delhi, then it gave a separate high court, and it gave executive to Delhi. So these are the structure that this 69th constitutional amendment gave to Delhi, right? So let me clarify that point again, that Delhi did not become union territory by the 69th constitutional amendment. Delhi was already a union territory since 1956. The only thing that this or only special provision, the heading of this article, sub article 239AA, the special provision when in regards to Delhi, when it is talked about, the only special provision or the few structures that it introduced was legislature. It said ki bhai it will have an assembly will consist of 70 members. How many council of minister it will have? So 7 council of minister. Then legislation on the all matters mentioned into the list 2 and list 3 of what you call schedule 7 it will do, except those 3 matters. So those 3 matters were police, law and order and land. So except on these 3 matters, all the matters mentioned into the list 2 and list 3, right, Delhi Assembly is empowered to legislate on all those matters, right? Parliament shall have overriding legislative power on the law passed by the assemblies, right? That point we already have. This is true not only in relation to the NCT of Delhi, this point Parliament shall have overriding legislative power. This is true even in relation to the Puducherry Assembly, even in relation to the Jammu and Kashmir Assembly, right? As far as talking about this executive, so the designation that was given to the administrator was Lieutenant Governor. So Lieutenant Governor and Council of Minister is going to be part of this executive. There shall be Lieutenant Governor who shall work with aid and advise with Council of Minister in so far as exercise of power is not in discretion of Lieutenant Governor. So this is something like the statement that we had read in the Governor's power. So this power is similar to the governor. However, there is difference between governor and lieutenant governor. See, governor is the head, and listen this carefully. This difference is very necessary, and there is one MCQ that has been appended on this particular point itself. So governor, he is head of state, and unlike governor, lieutenant governor is not head of state. What he is just agent of president, right? President was supposed to rule this union territory, but just because president does have the other administrative, legislative and other functions as well to perform, he has appointed a agent, right? So this lieutenant governor or chief commissioner or administrator, whatever can be appointed in these union territories, he or she is not going to be head of state as like governors in the states are. So that is one difference between this lieutenant governors or administrator and the governor's power, right? In case of, however, if there is any conflict, so what was happening in case of states? If there is any conflict between the governor, if he do not want to pass any kind of bill, if he do not want to sign any kind of bill, right, if he is disagreeing on any matter that has been referred by the assembly or council of minister, you had various kind of veto that we already have discussed. But here, if there is any kind of conflict between the decision or between the opinion of Council of Minister and these kind of confrontation, right, you had in Delhi case, and rather with the activist lieutenant governor in Puducherry as well, you have these kind of confrontation continuous going on in Puducherry between this Puducherry lieutenant governor and Council of Minister of the Puducherry. You can Google this kind of story. There is parallel government ongoing in Puducherry as well. There are some areas where lieutenant governor is parallelly trying to govern on, right, and Council of Ministers. There is continuous skirmishes, story of continuous skirmishes you can read into the newspaper between Council of Minister and the Lieutenant Governor in Puducherry case as well, and that case as well had gone into the Supreme Court, right. I do not want to get into the details, but you can Google out the stories of skirmishes between the Lieutenant Governor of Puducherry. Rather, few slides has been put up. I will not read those, although those points are very important from your mains perspective in 2015 and 2016. In Delhi case, when there was continuous case of confrontation between Council of Minister of Delhi and Lieutenant Governor of Delhi, there was continuous story. Again, you do have slides attached of those story with the timeline, right. I have taken the snapshot of Indian Express where with the timeline things has been attached. So here with the timeline that on what all points you had skirmishes between Council of Minister, elected Council of Minister of Delhi and Lieutenant Governor. So these are the stories, right, that you do have. And then so what was the Supreme Court's opinion? So these points I'll not read, these kind of story I'll not point out, right. These are the things that, because videos I am watching, right, continuously people are complaining that videos are, and already means I had planned that in 80 or 90 hours I would be able to complete the polity. We already have completed 70 hours and perhaps we will take another 40 hours in completing these whatever portion statutory and constitutional bodies. Rather, after completion of this part 8 of Indian Constitution, we will be delving into part 10 of Indian Constitution with the scheduled and tribal area, and thereafter we will be starting these statutory and constitutional bodies, right. So we are yet to take another 40 hours, and with the 120 hours only for the polity, I know means many people can, although those who are taking holistic approach, those who are preparing for pre and mains as well, those people are appreciating, but again this is getting bulky. For the mains, if you guys recommend, I can have a separate video when you pass this prelim. Thereafter, if there is popular demand, we can have separate video from the mains perspective, whatever chapter that is relevant for the. So as far as this Lakshmikant is concerned, and all the chapters of the polity that is not relevant from the mains perspective, you do have many dynamic chapters like Panchayat, chapters like urban local bodies. There may be questions on these kind of relationship stories, right. If there has been skirmishes between the governor, role of the governor that is being played into Rajasthan. So on the role of governor, there may be question. If there has been similar skirmishes at the central level with the president and the Council of Ministers, then again there can be. So these topics or these chapters are dynamic, and if you will suggest, I can have what you call another separate video for the mains. But right now मेरा अटेम्प्ट ये है कि अब वीडियोस को थोड़ा सा छोटा किया जाए. सो आफ्टर हैविंग क्लैरिफाइड दीज पॉइंट्स, जस्ट अ मोमेंट. So the 69th constitutional amendment gave this legislative, executive and judicial structures to Delhi. Rather, after this constitutional amendment, this Delhi was being called as NCT of Delhi. NCT of Delhi, National Capital Territory of Delhi. So that was another change that was, besides all these factors, that this was the another name change that was done by the 69th constitutional amendment. Now let us move to the next slide and let us start discussing this sub article 239AB. So article 239AB discusses about imposition of president's rule into these UTs that does have assemblies, right. You cannot impose president rule into the UTs, those 5 UTs, because those 5 UTs which does not have assembly, those are being ruled by the president itself, he has appointed. But the imposition of president rule can happen in the UTs which does have assembly. So these 3 UTs we are talking about, but the imposition of president rule in these 3 union territories with the assembly will not be by this article 356, but by article under the provisions mentioned into Article 239AB. So that is one point. Now discuss this Article 240. So if I discuss about Article 240, then it talks about the president can make regulation. Do you know the difference between regulation and the law? What is the difference between regulation and the law or act? So see, these laws and act are passed by any body, any representative body like assembly and the parliament. As far as regulations are concerned, regulations are issued by the executive body. It can be issued by the president, it can be issued by the governor or any head of state, right? So that is the difference between, or it can be issued by even what you call, at the district level, it can be issued by these DMs as well. So it can be called bylaw as well, and it can be called regulation. So that is the difference between, basic difference between this law, act and regulation. So let us try to understand that what this Article 240 is talking about. So Article 240 says that president may make regulation for the peace. So on these matters, if the matters are related with this peace, progress and the good governance for the union territories which does not have assembly. So for these 5 union territories, if parliament, so for these 5 union territories, we already have discussed that legislations are passed by the parliament. Now parliament suppose has passed any law on the matter called A in relation to these 5 union territories. Now this A matter or the A legislation that has been passed by the parliament is impacting peace or progress or interfering with the peace, progress or the good governance of these 5 union territories, then president, or you can say council of minister, because president does not do anything by his own, right, except what is in discretion. So that nuances we are not going into. So president does have power that he can make any regulation if a legislation passed by the parliament is interfering with the peace, progress and the good governance of the country. Then by the regulation he can repeal that law that has been, or act that has been passed by the parliament, just by passing a regulation. Let us read it again. President may make regulation for the peace, progress and good governance of the union territories. For this, president has overriding powers over the laws made by the parliament for these duties in matters of these peace, progress and good government, right? So I hope that point you will have understood. Now let us move to the next slide and let us start discussing this Article 241 that discusses about the High Court or provision of High Court for the union territory. So except 2 union territories, that is J&K and New Delhi, NCT of Delhi, there is no union territory that does have separate High Court. As far as Andaman Nicobar is concerned, right, उनका हाई कोर्ट राइट कलकत्ता में है, राइट, कलकत्ता हाई कोर्ट जो कि वेस्ट बंगाल के केसेस देखता है, राइट, वही अंडमान निकोबार के भी देखता है. As far as Puducherry's cases are concerned, those land into this Madras High Court. As far as Dadra and Daman and Diu, Dadra, Nagar Haveli and Daman and Diu is concerned, Bombay High Court. Punjab and Haryana High Court, चंडीगढ़ के केसेस, एंड देन लक्षद्वीप के जो केसेस है वो केरला हाई कोर्ट, एर्नाकुलम में जो हाई कोर्ट है उसमें देखा जाता है. तो हाई कोर्ट का प्रोविजन आई होप यू विल हैव क्लैरिटी ऑन. नाउ लेट अस मूव टू द नेक्स्ट स्लाइड एंड लेट अस डिस्कस अबाउट द पॉलिटिकल रिप्रेजेंटेशन. व्हेन आई एम सेइंग political representation, I am talking about this Lok Sabha and Rajya Sabha. So as far as Rajya Sabha is concerned, representation of these union territories into the Rajya Sabha is concerned, only 3 union territories that does have assembly, right? Because Rajya Sabha के members का election कैसे होता है? Rajya Sabha members are elected by people belonging to, or MLAs belonging to these assemblies, right? Because the 5 union territories does not have assemblies, so those people cannot have representation, or those union territories cannot have representation into the Rajya Sabha. So only these 3 union territories, that is NCT of Delhi, Jammu and Kashmir and Puducherry, does have representation in Rajya Sabha. As far as Lok Sabha is concerned, every union territories, all the 8 union territories does have representation into this Lok Sabha. As far as NCT of Delhi is concerned, for NCT of Delhi you have these 7 seats. For the Puducherry you have 1 seat, right, and for J and K, right, you have these 5 seats, right. Earlier J and K had this 6 seats, 1 seat has been transferred to this Ladakh area. So that is about the political representation, right. as far as recently changed character of this assembly, J&K assembly is concerned, right, you have this 114 assembly seat that has been given to this J&K UT with assembly. Out of that, 24 seat has been reserved or kept reserved for areas belonging to the Pakistan occupied Kashmir. Now let us move to the next slide and let us discuss these parts of lieutenant governor. And this slide has been particularly appended just to compare the powers of governor and powers of lieutenant governor. Governor we do have in regular state, and lieutenant governor or administrator that we do have in these union territories. So one point I already have pointed out while comparing the powers of governor and lieutenant governor, that these lieutenant governors are not head of state, unlike governor who in regular state are head of states, right, constitutional head of state. These lieutenant governors are just agents of the president, right. So unlike governor who is head of state or states, right, lieutenant governor is just agent of president in UT with assembly. Again, if I compare the second point, in case of governor in a regular state, right, he does decide that who is going to be chief minister, means he does all those invitation kind of job when election result has been announced, who is to be appointed, who is to be invited. So that job is not done by this lieutenant governor, right. As far as appointment of chief minister is concerned, and please understand the difference between appointment and swearing in, right. So there is a difference. So as far as appointment of chief minister or council of minister in UTs with assembly is concerned, that appointment is done by the president. The role of lieutenant governor is just limited to swearing in, right. So the difference, I hope you will have an idea on that what is the difference between appointment and swearing in. So 2 points I hope you will have clarity on. Lieutenant governor should generally abide by the advice of elected council of minister. In case of conflict of opinion between lieutenant governor and elected council of minister, and these points we are talking in relation to only those 3 UTs which does have assembly. So what was the option that was available if governor of a state is not satisfied, or if he does not want to sign any particular bill? What are the options? So you had this veto power, but those kind of veto power is not available at the disposal of this lieutenant governor. The only option, if he is not appreciative, if he is not agree to the ideas that has been, or to the bills that has been presented to him after being passed by the assembly, he has to forward that matter or refer that matter to the president. The next point, lieutenant governor with respect to the, so the ordinance making power as far as this governor and lieutenant governor is concerned, right, is on par with lieutenant governor's power on ordinance making is on par with the governor. Again, the only difference is that when the house is dissolved or suspended, at that moment lieutenant governor cannot enact this ordinance. However, lieutenant governor has a special responsibility towards UTs and he should work accordingly, right. So this was all regarding the powers of the lieutenant governor. Now with this we are wrapping up this lecture, right. These points I already told you, right. These points you can read by yourself. These are just stories of skirmishes that had between Council of Ministers of Delhi and Lieutenant Governor. These are a story of skirmishes between Puducherry Chief Minister, Puducherry Council of Minister, and the Lieutenant Governor of the Puducherry. So these are stories of skirmishes. I hope you have been reading these current affairs, right. So these are the things. Should Lieutenant Governor participate into the day-to-day administration of the state, right. So that is in relation to the Puducherry Lieutenant Governor, right. Should he? So here I have raised this question. Now the point as well, the answer has already been put up here as well, right. You can simply, when you will get the PDF, you can read all these points. Now we are getting into this question section. So this is the first question that I expect you to attempt. So there will be 4 questions, second question, third question and 4th question. So these are the 4 MCQ that I expect you to attempt. The next chapter would be on schedule and tribal area, that is 5th and 6th schedule. So till then, bye bye.